Good afternoon, and thank you all for joining us today for this very important conversation on empowering consumer voices through navigating the public consultation process for effective policies. My name is Antara Vasudev, and I lead an organization called SEBI. I'm joined by my colleague Shachi, who will be co-facilitating today's session with us. Before we begin, I just want to start by sharing a note of thanks to our colleagues at CUTS, Amol, Akshay, Arima, and the entire team that has been hard at work to put this workshop together, as well as to our speakers, Dr. Sahoo and Mr. Pramod Rao, both of whom have taken out precious time from their schedules to be with us today. Today's agenda, and perhaps we can just start by talking about that, is we have about 2 hours for this workshop that we have together. And through the workshop, our goal is to be able to talk a lot more about how the process of public consultation can be navigated by individuals, by consumers, as well as by institutions. However, the flow that we thought might be best to actually go into this is we'd start out with a little bit of an introduction, talk about the significance of consultations, then move into talking about the process of participation. How do you navigate it? How do you engage? We have case studies, a few opportunities for questions and conversation, as well as next steps in taking action. How do we continue this journey of being active citizens in this domain? Interspersed between a little bit of the theory is we're very grateful to have 2 eminent speakers join us who will be going much more deeper into the practical aspects of public consultation from their varied experiences as well. We will get to that in just a few minutes, and I don't want to take up too much time before our guest speakers come in. So we'll just start with the introduction to the process of public consultation and then go forward from there. To introduce the pre-legislative consultation policy, and we were just having a very interesting conversation about whether this is a good moniker or marker for consultation in India. We have a short video that we'd just like to play. What I would request is my colleague will pull up the video. But if you can hear the audio well, I would just request anybody in the audience to share a thumbs up so that we know that, that you're with us on the same page. And that would be the best introduction to PLCP, after which we'll come in with a few more comments. Just allow us a minute to pull up the video.
So while the video has been pulled up, I would like to join Civis team in welcoming Dr. Sahoo and Mr. Rao, who have agreed to grace this workshop, and really thank Civis team also to put this together. Also welcome all the participants. I can see a lot of old faces who have worked with CUTS for decades now to raise the flag of public consultation, and look forward to a more effective and engaging conversation over the next hour or so. And also, please feel free to sort of put in your comments, questions on the message box. And this is also being live streamed. And please feel free to watch this on YouTube also if you would like that. Thank you.
Thank you, Amol. All right, we'll just give this video a go. All right, so we've given you a spoiler of what this video looks like, but unfortunately, I don't think we'll be able to play it today. I think we're just experiencing a few technical issues with sharing computer audio. We will, of course, share the link with you to take this forward, and perhaps if one of my colleagues could, Shanotra, if you're in attendance, if you could just share the link, that would be great. But we wouldn't distract you from what we're hoping to achieve today. The video is very entertaining, I promise, but I will try and be just as engaging as I talk about the pre-legislative consultation policy. In essence, what we were hoping to cover is just to share that the process of engaging with government has been long-standing in India. Even pre-independence, or even in different rulers and rajas that have had existed in the country prior to independence, we've seen that there was a lot of consultation and conversation between citizens and governments. This process has now in a democratic state taken on new meaning and has actually become even more powerful. And today we're looking at how do we navigate this entire process. In India, we have a 2014 policy, the one which you see to the right of your screen, which was passed by the Ministry of Law and Justice, which actually encouraged the formalization of consultations in the country. This particular policy is known as the pre-legislative consultation policy, which is quite the mouthful. So you might hear and see it referred to as PLCP on your screens. The key mandates of this policy were rather simple. The idea was to ensure that every department or ministry should publish its proposed legislations in the public domain, either through their websites or through the Gazette, and ensure that citizens and concerned stakeholders have adequate time to make their representations to the department concerned. The idea, and we'll wax eloquent about the benefits of this process through this call, but I feel like the idea really is to ensure that there is participatory lawmaking, and that the concerns of the stakeholder who is most impacted by a particular policy is taken into the policy making process at the right time. Another key mandate that this particular policy put forth was that where there is a specific group of people impacted, the department or ministry must ensure wider circulation of the draft so that it reaches those communities. One example here would be, for example, if a department or ministry was to reach out to CUTs, knowing that they are a representation of consumer voices, and request them to further populate this particular policy within their stakeholders, some of which are here today. The legislation should ideally be kept open for a 30-day period for public feedback. This window allows for much more conversation and informed decision-making, first within communities and then between communities and the government. Along with these three key mandates, there are a lot of other different mandates that the policy puts forth. One of them is on ensuring that any draft law or policy has an understanding of the economic and social implications of that particular policy, as well as the environmental impact of that policy included in the draft itself. A number of different provisions also borrow from the Administrative Procedure Act in America, as well as different other legislations across the globe that have focused on ensuring participatory lawmaking. As you can see, I'm quite passionate about the subject, and I don't want to go too deep before we get started. But in introducing this concept of PLCP, I also want to emphasize that such consultations, as Dr. Sahoo was just pointing out to a few of us who were on the call earlier, have been in existence through various legislation and statutes, differently through regulators, as well as through lawmaking bodies for many, many years to come. Many years to go. This formalization has taken place in 2014, and that's one of the anchors that we are relying upon today. Going forward, I think we'll now talk about the policy making cycle and how exactly consultations play a role within that. And I'll invite my colleague Shachi to take us through what that process looks like and how citizens can intervene.
Great. Thank you so much, Antara. I hope I'm audible. Very good afternoon to all of you. Thank you so much for joining us. Taking over from what Antara has just told us about how PLCP coming in really changed the game, and we'll explain a little bit further as we go along. What we'd like to focus on at this moment is where exactly in the policy making cycle are consultations important? Now, the simple answer to a very complicated question is at multiple stages, right? So as much stakeholder feedback, as much valuable input coming from the end users of a particular policy into the policy making cycle benefits that policy being well-rounded and ensuring that it looks at all aspects, ensuring that everything from large-scale protests to harm that can be caused by policies is avoided right at the policy-making stage itself. Now, coming to the policy-making cycle, it's debated that there are many different ways to look at it. Some say there are 6 steps, some say there are 12, Harvard annotates 9. We've taken an amalgamation of all of the theories in the world and tried to put something together for you. Very simply put, once the agenda setting or identification of the issue is done, there comes the stage where the basic policy objective formulation is required to be done by the government and involved players. At this stage, it's important that expert feedback from stakeholders that are well versed within the domain that the policy is being built in are consulted to ensure that the very basic foundation of that policy covers all its bases, right? Moving on, once that fundamental base idea or the policy objectives are arrived at, it's important to widen that net and to really consult a larger scale of stakeholders. Now, at any given stage, when you're mapping stakeholders for a policy, there are primary, secondary, and tertiary stakeholders. While it's important that primary stakeholders are focused on and ensured that their needs are covered, that all adverse effects are mapped, it's also important to ensure that secondary and tertiary users of that policy are looked after, which is where the stakeholder consultation open to the larger public comes into view. Once that's done, the policy goes into a further drafting stage where the know-how or the nitty-gritties are assessed and they're put together. At which stage, before adoption, it is important that a large-scale review of that policy is undertaken, again, to ensure that no repercussions may come out of a policy like this. When we're speaking of making a policy for 1.3 billion people, I think the more care taken, the better. And with that in mind, we recommend policy stakeholders to be involved in the conversation at all of these 3 stages. However, the story doesn't end there. Once the policy has been adopted and it goes into the implementation stage, there are obstacles, there may be problems, or there may be unforeseen challenges that might come up. Therefore, it is important that the policy also undergoes an evaluation and a feedback loop is created fundamentally between the citizens and the government to ensure that all policies are acting the way that they should, that they're meeting the objectives that they were set out with, and that the citizens are actually the end beneficiaries. Now, all of this very complicated talk is ultimately explaining a very simple idea, that the governments and the citizens must always be in conversation. Now, what public consultations really do is build that bridge or provide a forum for that conversation to exist and flourish. Moving on, I'd like to now talk about the opportunity that the formalization that PLCP brought, which Antara mentioned previously, has given us, right? While consultations have existed in an informal setup throughout time immemorial, what we've seen from 2014 is a very interesting, sharp uptick in the number of formal official consultations done by ministries at the state and the central level, as well as, in fact, the local levels as well, at the municipal level as well, seen a sharp uptick in that number. In fact, it's gone up quite a fair bit in 2023 as well. And thanks to all of the regulators, the ministries, and the state departments. With that, we'd like to also talk a little bit right now about the significance of PLCP. Now, I think for citizens, it's a slightly easier facet to understand, right? What do citizens get out of participating in the lawmaking process? Well, we get to influence the policies that really affect us. It contributes, we are able to contribute to the activity or the giant task of building a nation through our lived experiences, through our knowledge, through the reservoirs that we contain just surely by our experiences, right? And we also get to say, to have a say in the decision-making process. Why should governments consult? And I think our speakers today will help us understand a little bit more about that side of things. But just for as far as we can see, what really helps the government when it comes to consultations is to make the policies that are actually relevant to the stakeholders, is to avoid any repercussions of policy decisions that may be made in silos, and to really add value to their citizens. As we know, that is their aim. Moving on, does the PLCP also apply to regulators? No, it does not. The PLCP is a policy that was put out, the circular that was put out by the Ministry of Law and Justice, specifically mandating the action of consultations among the states as well as the central ministries. However, regulators in our country, bodies like TRI, like SEBI, IBBI, RDA, have come up with their own set of SOPs simply by virtue of the number of consultations that they've undertaken. Some interesting practices that we'd like to just touch upon before the experts really come into the room and educate us all. One thing that TRI has built a practice of is publishing the comments, the public comments that they receive, and also allowing for counter comments to those public comments. We find that a very interesting way of building that dialogue that is so very important in this entire process of civic and government relationship, right? And another thing, IBBI has also built a format for, as you can see on the right side of your screen, it's a little bit hidden, but there is a clear SOP developed for recording the results of these consultations. Because what really happens when all of this feedback, or like the government sometimes receives 40+ lakh feedback points, as is the case with the Uniform Civil Code, where does this go, right? And building that process, really scrutinizing, making it transparent, making it accessible, is part and parcel of building that process out. And that's something that we found really interesting. With that, I'd have the great pleasure of introducing our first speaker, Dr. M.S. Sahoo, who is a distinguished professor at the National Law University of New Delhi. He has served as the chairperson of the Insolvency and Bankruptcy Board of India, which is IBBI, and a member of the Competition Commission of India, CCI. He has also previously served as a whole-time member of Securities Exchange Board of India, which is SEBI. Right? With that, over to you, Dr. Sahoo. We're so excited to hear what you have to say.
Thank you. Thanks to Civis and courts for having me here. My grateful compliments to them for their endeavor to professionalize the process of making the regulations. I think the public consultation has been the flavor of this season of late, and we have seen a series of consultations, a series of invitations from public. They say, for example, in this October, we have seen invitations from about half a dozen regulators seeking suggestions for reviewing the existing regulations. And this has essentially followed from an advice in the budget last year. Why I wanted to emphasize is that on this budget part is that there was an advisory in 2014 by the law secretary to different departments to engage in consultation. But beyond that, I think we have proceeded we have covered a long distance thereafter. If you look at this year's budget announcement, particular para 99 and 100, that says that to meet the needs of Amrit Kal, to facilitate optimum regulation, etc., public consultation will be brought to the process of regulation making and subsidiary directions. And then it went on further to say that to simplify, ease, and reduce cost of compliance, financial sector regulators will be requested to carry out a comprehensive review of existing regulations, and for this purpose, they will consider suggestions from public. So the first part talked about, for having the optimum level of regulations, please consult the public. Second part talked about, please review the regulations, and for that purpose, consult the public. So this is a budget intention. In fact, as I told you, the recent spate of invitations for suggestions has come from several financial sector regulators. But consider this in the context that in the April 2023, the Parliament enacted Competition Amendment Act 23 that again specified, mandated the competition regulator to consult the public for making regulations and prescribe the manner of making regulations, manner of consultation. And also it mandated that there must be periodic review of existing regulations. So the important point is that we all know regulations are important, public consultation is important. In the market economy, regulations should be there just only to address market failure and not do anything more than that. But yet, these two government interventions recently, there are a few others also, one generic through budget document and one specific Competition Amendment Act. These two interventions have a broader message for every kind of legislation or subordinate legislation being made. And of course, this intervention has come after realizing that we are not doing enough in this space. There is some deficiency, otherwise the government would not have intervened. Some deficiency either in the quality or quantity of regulations. And I am not getting into the why public consultation is necessary. Even Supreme Court in 2016 in telecom matter only had also advised the government to have an act like something American Act of Procedures to do these things. But let's come to the specifics, the subjects of this session, the strategies, the how you achieve it, what care you have to take. First is this scope is not limited to legislations. It is limited to everything which prescribes a norm for the regulated. It can come in legislation, subordinate legislation, it can come in, as rightly the word used in a budget this year is that it applies to regular subordinate legislation and all subsidiary directions. That essentially means it applies to, you should not be resorting to a tool which is not called regulation. You could resort to guidelines, orders, circulars, and yet prescribe the regulatory norms, and therefore you can escape the public consultation, the regulatory impact assessment, due process of law, due process, the what we call procedural accountability. That's why the focus is that the budget is trying to catch that. Please use this public consultation for regulations as well as subsidiary direction. This is the first part. The second is that do this at the time of making the regulations, and while making regulations, though it is not saying very specifically, but as a strategy, if you want the consultation to be effective, you must put out why you are doing this regulation, what is the expectation, what is the impact assessment of this, and in fact, this will enable you, this is a kind of procedural accountability, ex-ante accountability, ex-post accountability. So when you talk about review of regulations, I'm linking to that regulation making and regulation reviewing, that once regulations are made, they remain in books for a long time. And even if they lose their relevance, you would have seen the Regulation Review Authority of Reserve Bank of India. They did one round of regulations review in 1999 and another they did in 2021. In 2021, based on the review, they repealed 750 circulars. So that is the impact of, that is the finding that 750 circulars had outlived the utility and they need to be junked to reduce the cost of doing business. So therefore necessary to weed out the regulations, and you know the government also carried out this exercise. They have junked also several legislations. So we have to weed out the regulations or laws which have run out of time, context, relevance, make them contemporary to the business dynamic, business setting. Next is that quite often we come out, in fact, SEBI, the modern type of consultation we see, it began with the SEBI in 2002 actually. So there is no regulatory requirement, but SEBI came up with several modern practices. In fact, SEBI is the most evolved regulator on many aspects. People try to emulate the SEBI, either SEBI or SEBI statute. Because a problem is encountered fast in our market environment in the context of SEBI. So either SEBI finds out a solution or government finds out a solution in the SEBI legislation, and both, whatever is provided in SEBI legislation or the practice SEBI evolves, those both have been replicated in other legislations and other practices. So the modern way of a public consultation begins with the SEBI from 2002. And now we have consultations have taken different forms. And in fact, now statutorily, many regulators are required to have advisory committees. SEBI does not have that requirement, but it has probably maximum number of advisory committees. But other statutes require advisory committees, working groups. Now the regulatory boards have public nominees to get the voice of the outside. So many things have come up. But quite often what happens is that many regulators remain content to the sharing the discussion paper, not share the draft of the regulations. And quite a few regulators also approve the regulatory proposal, but do not approve the language, the draft which will be notified in the Gazette notification. So what is required is that regulatory board, actually this is the only function regulatory board does, which cannot be delegated. Every other function of the regulator can be delegated except this function. And this function means that they must see every comma, stop, whatever is written, notified under the signature of the whosoever the authorized person. So therefore, the consultation is effective if you put out the draft of the regulation so that people know actually, because it all depends on the language is used. Intention could be something, but meaning could be different. So it is the language that has to be approved. The Parliament of India approves the legislation, does not approve the legislative proposal. The exact proposal has to be approved. Therefore, the exact proposal has to be put out to public for comments, and that proposal should include not only regulations, but also the subsidiary directions. The public consultation is not new, but how you engage is becoming more new and more effective kind of things. But it's while public consultation is necessary, but how intensely you do it decides the effectiveness of this. Several things about SEBI has tried, at IBBI also I have tried. One can make a documentation on those things. But important point I wanted to make is that this consultation will be effective if the regulator presents the draft of the regulation along with a regulatory impact assessment of such regulations that enables the regulator. Regulators are not specialists. They can understand, if you give them something, they will apply mind, what is good, bad, what will work, they can tell, but they don't know the technical details. So for them to appreciate the rationale and implications, you must, otherwise they will not understand. You can give 10 days, 15 days, and that's why quite often we find very minimum participation in public consultation. And it is meaningful if you do the review of regulations at regular intervals, not budget wanted, this will do today. It has to be every, actually, unless it is warranted earlier, it's to be routinely done every 3 years. And I gave you the example of gains from RBI review. And for that also, regulators should tell, like the clauses to the legislation as you find in the legislative bills, that the regulator should tell, by this regulation, sub-regulation, sub-clause, I intend to achieve this objective. I have done it 5 years ago. This is how it has performed. Therefore, you tell me that whether these regulations still continue to have a relevance, or are there better ways of achieving this? Unless you tell that this regulation has this purpose, the regulator does not know why you want to continue it or why you want a review. Again, as I told you, they are not specialists. Regulator is a specialist. They have an army of people who have specialized in this. Over and above this, we have to use technology. IBBI, in fact, though it was a very new regulator, but from the very first year it used a technology, and probably it does alone that technology, that kind of technology, not that technology others have also. The kind of technology I told you, every clause, sub-clause, line. So IBBI gives that option that please comment regulation-wise, sub-regulation-wise, clause-wise, all that you want to say. So you must use the technology also to make it effective. But beyond this, what IBBI does, and I think that should be also followed by others, that should be practiced for others, is that the public consultation what we have today is a kind of passive participation. We tell the regulator that this is what I want to do, and I am giving you 21 days time window. please tell me if it is okay or not, or give me some suggestions. And somewhere people will do lobbying, some people will send mails, thousands of mails just to show that many people are interested. But what is, I would say that, can we not the regulated, they sit closer to the market. In fact, the regulator substantially depends on the regulated for understanding market developments and designing solutions to emerging concerns. So the regulated have the first-hand experience of the concerns of the markets, and they understand it faster, they get to know of the faster. And given their number, the universe of practical solutions they can offer would be much larger. Can they not be given an opportunity to ask for or suggest new regulations or changes in existing regulations at their leisure, not a 21 days timeline? And what can help to make the business easy to do business? And then you keep it a window open for 3 months, 6 months. IBBI does it from April to December. IBBI, as I told you, following the budget discussion, IBBI has also sought suggestions this year in this October 3-4 days ago. They also consult on every piece of draft regulation. But what IBBI does is that it says that this is all my existing regulations. Why can't you regulate it? You examine, you suggest from April to December anything you want in the change in regulation, new law, new regulations, anything you want, you tell me. And I will examine those proposals. In fact, the other way that in earlier version, regulator invites public comment. But here it can be the just opposite, that public give the suggestion, regulator comments on the suggestions of the public, whether it is worth taking forward, and wherever it considers that it's worth going forward, again you have to follow the due process and then notify the regulations, maybe say on 31st of March, so that market knows also there's a calendar that new regulations, usually unless there's an urgent necessity, we should not be disturbing regulations every day. That also disturbs so many things, that has a cost also. But have a system that whenever required, do it throughout the year. But you can have a calendar that people know if they have given suggestions from April to December, those are processed in January and February, notified on 1st March, they will come into effect from 1st April. And that new regulations, people have the idea they are ready for the next, they get time to become ready. So why not we put the regulated in the shoes of the regulated? Sorry, why not we put the regulated in the shoes of the regulators? So they will participate in the public consultation, but they should be able to move the proposals on their own. I think these are some of the suggestions I had about your regular public consultation strategy. Thanks to SEBI and courts for giving me this opportunity. Thank you so much.
Thank you so much, Dr. Sahoo. I think you very well illustrated the systems that facilitate change. But I would also like to mention to all of us in the audience that it's not just systems, but champions within the system like Dr. Sahoo and Mr. Rao, who have joined us today, that actually move the innovations in this domain forward. So thank you so much for that. Moving ahead, I just want to share a little bit of context before we call upon Mr. Rao to share some inputs. We'd like to look at this from a case study approach of a recent SEBI regulation that was published on consultation paper, which was published on strengthening the investor grievance redressal mechanism in the securities market in India by harnessing online dispute resolution mechanisms. This particular consultation was open for a 39-day window, with many respondents coming to the consultation from different perspectives and walks of life. A lot of extensive outreach was done on this particular consultation, and different groups, investors, individuals, and others were able to come in and comment on this particular policy. What we have seen is that a lot of that feedback has since been incorporated into subsequent circulars that SEBI has put out as well. And this case study just serves to illustrate the power of consultation and the power of individual voices within this process. I wouldn't spend too much time on this slide. Rather, I would like to hand it over to Mr. Rao to tell us a little bit more about the public consultation process and his perspective from the regulator. I'll just quickly introduce Mr. Rao, though I'm sure he needs no introduction. He's an executive director at the Securities and Exchange Board of India, which is SEBI. He's handling the debt and hybrid securities inquiries and education departments, as well as the quasi-judicial cell at SEBI. Mr. Rao has an extensive experience in the Indian financial services sector, having served as Group General Counsel at ICICI Group, General Counsel for Citi South Asia, and as a partner at Indus Law. Without further ado, I'd like to request Mr. Rao to please share his comments with all of us.
Thank you. Thank you so much, Antara. It's a pleasure to have heard Dr. Sahoo, and also thanks to Civis and CUTS for putting this together. When I spoke originally to Antara, I think the outline was to explain how, in context of a case study like the ODR, what is it that public consultation entails for a regulator? And that's what I'll really attempt to do over the next 15-20 minutes. But I wanted to build on certain points that Dr. Sahoo made, and I thought it will be important for the audience as well. I think, just as a matter of the public consultation policy that Ministry of Law had released in 2014 was mentioned, I went to the SEBI website to look at what was amongst the earliest consultations SEBI had done. And that dates back almost to 19 years, 2004, October, as a matter of fact, when one of the first papers for public comments was released by SEBI. But as a practitioner, I can tell you that it dates back even further, because there have been always committees that have got constituted whenever major reforms have been thought of, some to shape those reforms or to frame those reforms, rather than saying that there is a preconceived idea of what we want to do. So an example I can take is, Mr. Kumar Mangalam Birla chaired the Corporate Governance Committee report, authored that report. It got refined under Mr. Narayan Murthy and more recently Mr. Uday Kotak. And what that committee did was it got a host of industry leaders, academics, practitioners onto looking at what actually should these standards look like. And to me, that's a demonstration of public consultation. We can debate whether it should go to the full length of citizens, but my belief is even a representation of that at some level through these committees that I described shows that actually regulators are quite interested in getting that feedback, getting those inputs, and indeed helping shape the policy changes and reforms that are required. At SEBI, I can also say that there are various standing advisory committees. These become inputs from the industry and practitioners again to sort of say that can you relook at such and such regulation? Can you craft some new regulation because there is now an emerging trend or a threat to the markets and so on? So I think again, each of that plays to the strength of what I call feedback, which otherwise might place policymakers or regulators in ivory towers. So to me, it's quite important that we get that input, we get that feedback, and then action upon it. And I would say it's hopefully not unique for SEBI at all. RBI has constituted several committees which constantly look at various different aspects. IIDA as well, with the new chair taking charge, again led, I think, almost 10-15 committees being constituted. But I agree with Dr. Sahoo's point that maybe there is still a lot more framework to be put into this because some of it appears ad hoc and so on. And hopefully I will try and articulate how at least I have experienced it firsthand at SEBI and how we have tended to see it. I should also acknowledge that over the last year or so, we've partnered with Civis, I think 2 or 3 times in putting together an outreach for getting more specialist feedback. while our consultation papers have always been open for direct feedback from interested people interested in that. But Civis has helped us both marshal some of the more nuanced feedback, reach out to people who might otherwise have not thought about looking at these papers. And I wanted to just call that out and acknowledge that. So thank you, Civis, for that. On the ODR, so that slide was just showing, there were various, public commentaries, reports, and so on, which articulated that ODR is indeed something which can help both the citizenry, the consumers, and so on, in getting faster relief, in getting relief which is maybe more customized to what the consumer needs are. And it was natural for SEBI also to start thinking about that. And it started looking at these papers, started evaluating what did it mean for us to look at ODR. One thing which I must mention is, and Dr. Sahoo will bear me out, SEBI rarely gets into intermediary investor disputes. It is seen as more in the contractual realm between them. Intermediaries, however, do get disciplined if they breach regulations that SEBI has made. So there is a distinction I want to make about, what are the service obligations that intermediaries have to their clients and to the investors, which SEBI does not get into, versus where intermediaries might breach codes of conduct or regulatory framework, where SEBI will indeed discipline them. So this led to a situation where we realized that the intermediaries were each choosing their own model of dispute resolution with their investors and consumers. Some which were more convenient or suited to the intermediary rather than to the investor. The second was, we also had a great example playing out in the stock market, where we had the stock exchanges administer both conciliation and arbitration for broker client disputes. And given the volumes of transaction occurring on the stock market, we were actually quite pleased with how the system was functioning there. Because what it meant is that there was an effective means of addressing the investor issues which they had with brokers, and which was occurring either through conciliation, at that time labeled as IGRC, the Investor Grievance Redressal Committee, but really practicing conciliation measures as such. And if IGRC failed to, help the parties get to a conclusion, it led to arbitration administered by the exchange, which selected and appointed arbitrators for doing that. So our thought was twofold. One was that could we upgrade the stock exchange mechanism and get them to embrace ODR both for the IGRC portion and the arbitration portion, thereby making it online. Otherwise, what was occurring was that these were being conducted at regional centers, or being location constrained by where the arbitrator was and requiring the investor intermediary to travel. Whereas to our minds, online sort of made it equidistant for everybody, because you could participate through your smartphone or through a computer, laptop, and so on, making it easier at some level for people to participate. Again, when we looked, like I said, we had the first bridge, which was intermediaries which stipulated their own dispute resolution process. We had a successful model here, and we decided to combine it for the entire securities market. Doing so, while we were progressing on this, clearly what it meant was there would be a sea change for the investors and the intermediaries. This obviously compels then the consultation being triggered. And like Antara and Sachi mentioned, we floated a consultation paper end of December, and it stayed open for almost 40 days. And we were looking to what kind of implications did it mean for people. We had open-ended questions because, again, we were not templated into saying that we believe this should be the answer. For us, it was that what was the feedback that was coming in? What did the intermediaries, investors, or stakeholders really think should be the approach to be adopted? And I think I saw the statistic there saying that almost 30% of that feedback and input finally featured in our circular. I think it came because, again, like I said, we laid out what we believed could address all of these concerns that we had around dispute resolution and so on, but were open-minded and open-ended enough to saying that we are happy to go with the feedback from the public, from the experts, and so on. And I think that helped shape what finally emerged. I should mention that typically a consultation will get taken to an advisory committee before we release it to the public. So we get the experts on the advisory committee to look at what our proposal is, what kind of draft consultation paper are we thinking of putting out. We factor that in and then release it to the public. Once the public comments come in, we go back to that advisory committee and showcase all of the comments that have come in. There is usually no editing that we do. There is maybe summaries that we present, but we also append the exact comments that have come in for members of the advisory committee to be able to look at what was actually said and in what tone was it said and so on. With those tonalities and those inputs, the advisory committee debates and then gives us their viewpoint. We combine all of this. We look at, therefore, the public comments, the advisory committee's initial and post the public consultation comments, and synthesize and make a proposal which we take to our board. Again, our board usually wants to hear both. What did the public say? What did the advisory committee members say? And then they sort of reach a determination of what to do. There can be changes even at the board level to our proposal. And at times, then the board might advise that you please do further homework on this or make these modifications and changes and then go forward. Or they accept our proposal. So all of these can sort of pan out. Usually, immediately post a board meeting, we issue a press release which outlines all of the proposals and their status, so as to speak. And subsequently, when the minutes of the board are confirmed, the minutes also get published at a quarterly interval, which means minutes go obviously to the next board meeting, and after that board has looked at those minutes, those get published. So those interested in tracing this journey would actually end up finding there's a consultation paper, there is the board, immediate release after the board meeting, which is considered that matter, and finally board minutes that come maybe subsequently in a quarter's time of that. So this journey has been pretty consistently followed in as many matters that at least I've had the chance to observe. Can it do with further refinement? Can it do with further inputs? My belief is for sure. I don't know if you saw, those of you saw that screen which was just put up by Shachi, but when you have only 40 comments coming in, at times you wonder, is this sufficient, right? Should it be 400? Should it be 4,000? You know that some of the reforms that are being proposed will touch life of millions. May not be, even in single digits or double digits feedback that is coming. But if that is going to be the implication, how do we sort of keep track of it? So one of the things we did on particularly the ODR portion with the Civis was, we asked them to look at newspaper reports and commentaries that had featured or talked about this paper. So even though those individuals or publications may not have written into us, we said we were keen on getting what was the sentiment expressed or what was the recommendation that they had, so that we could factor that in as well and not have a blind spot or miss out something. Again, that became a very valuable sort of thing for us as we progressed on the ODR piece as well. To me, the other culmination as we got our board approval was that we wanted those that were now charged with implementing it, which was primarily the MIIs, market infrastructure institutions. We constituted a group of them to sort of start looking at how do we make this, what was now a policy formulation getting approved by the board, how do we put it into shape? And what I can share with the audience here is that I think they took almost 3-4 months to put together each of the operational nuance which they felt needed to be dealt with, and which they were themselves, coordinating with the ODR institutions, looking at other intermediaries which never had a dispute resolution process in the first place. One of the concerns that I said we were trying to address, and their own processes which were governing the broker client and so on. So a lot of homework then went into how to make it operational. And that is why finally our circular got released end of July. We had a forward date again because there was a platform to be developed, put into motion, and we've staged it. What I can again report back, and this I look at as the success of delegated legislation to regulators such as SEBI, is that we continue to get feedback. We continue to, as people start experiencing the regulation, the circular, there will be issues that crop up. And when they write into us, we are again able to evaluate and sort of figure out, okay, something needs to change. This is now an impediment, or this was not attended to earlier, and so on. So some amount of refinement starts to occur. I would again say maybe in a couple of years, once we have absorbed and got a lot of learning from how this is working, there may be yet another sort of relook at it to figure out, is there anything more to do? But that, I would say, is the journey of at least how this particular thing has progressed. And I'll pause here. I'll request Antara and Sachi to jump in with any other thing which I may have missed, and happy to take any questions if anybody has.
Thank you. Thank you, Mr. Rao. I think that was a very good explanation of the entire process from start to finish, and quite interesting for us also to learn about. We do have, I feel, two questions that perhaps we could tackle at this stage. One question from Rajesh Kajra says, isn't there a real risk of SEBI's summaries of public comments when taken to the committees? Would it not be the preferred method to share the unedited comment played back to the panel? If you could address that, I think that would be one question. And the second question specifically pertaining to SEBI's efforts is that given that SEBI has been a pioneer in the public consultation process, are there any impediments in implementing the FSDC resolution of October 2013, talking about non-legislative recommendations of FSLRC towards institutionalizing public consultations and cost-benefit analysis in regulation-making processes? So I think we'd have time for two questions. One on the procedural aspect of how do you engage further with the nuances of certain submissions, and the second one on the regulation and implementation.
So I did mention when we present, the public comments to our advisory committee and our board, the unedited version of what we have got is presented to them. We do have a summary sheet, but I would say more than that, there are obviously all of the actual comments that have come in are presented unvarnished, unedited, exactly as it is for the members, both of the advisory committee as well as the board to look at. So I hope that addresses the first question. On the second, I would say it's more about a practice itself that we do all of these consultations. And I think I'd invite the members of the audience to look at our website about reports and reports put out for public consultation. You will see it, as a continuous stream, which is being consistently followed by SEBI all across. And I would say in our new rulemaking, or for that matter, changes to regulations which are substantive in nature, our practice is indeed to have a consultation issued, a paper issued after consulting the advisory committee and going back and so on. So in terms of public consultation, for sure, it is happening. In terms of cost-benefit analysis, I would put it in twofold bucket. I think one is that the actual cost, for instance, a measure like I would say the ODR, right? When we have unregulated, or rather non-specification of how intermediaries could deal with their investors and consumers, it could lead to any formulation of dispute resolution that may be Could be arbitration, could be leaving it to courts, could be just staying silent on dispute resolution and making the investor, go around in circles. How do you put a cost benefit to it when we streamline it and say that now it should be in an end-to-end manner completed within 90 days, right? I would say that that will tell us as we see this play out and compare it to really the data, but that data might be non-existent or for that matter scattered because there was never a common regulation at all. Yes, there is a portion of it, like I mentioned, the stock market did have IGRC or the conciliation and arbitration. So there is some comparison that is available about what happened and how it happened, but it may still not cover the entire market. So at some level, this ability to quantify, I would say, is still difficult at some level. I would equally go on to say some of our measures. It's what I have sort of read in the book will just come to me. The name will just come to me. But how do you put a value to a measure that you take which prevents a catastrophe, right? Several of the things that the regulators do is to prevent a meltdown or a investor confidence vanishing and so on. These risk mitigation measures, unless you had a simulation which could tell you if we didn't do this, this will happen. But those are the same potentials that we look at in preventing, in not allowing those to come to pass, right? So to me, I would say that it is difficult to quantify. What we are starting to do is to start talking to our intermediaries and asking them as to what is it that is the cost of compliance they assess. Is it a compliance officer? Is it a compliance team? Is it a cost of capital? And so on. But I would believe that we are some degree away because many of them, and candidly, I've been on the other side maybe a year and a half back and prior to that. It becomes difficult to say what do you attribute to a SEBI versus, let's say, a Companies Act if you're a company, because you have to have a company secretary. Does the secretarial department cost be the cost of compliance with Companies Act? And if the same company secretary is now a compliance officer as a list for a listed company, there is things which he has to do vis-a-vis the listing requirements. So how do you attribute or how do you apportion these costs? And these are things which we need to get to the bottom of. I'm not going to tell you that we shouldn't, but I think we are making a start and hopefully going to sort of get there. Is the way I would put it. But let me pause there and see if there's anything more.
Thank you, Mr. Rao. I think that covers some of the audience's questions for us today. And I just want to acknowledge and thank both our speakers for sharing their comments very candidly and also taking us through the consultation process. With your permission, I'd invite Shachi to take us through the next steps of how can we actually engage as citizens in this process, and how do we, as having understood the system now, take some of these words and inputs into action. So Shachi, if you'd like to go ahead and share your screen once again.
Absolutely. Thank you so much, Anta, and thank you so much to both our speakers. It's been quite an interesting conversation so far, and I'm sure the audience echoes my sentiment. Coming to some of the more action-oriented parts of our session today is what does participating well in a consultation process, which itself is in development at the moment, as we heard, what does that look like for citizens, right? And at Civis, of course, like Anta mentioned, we've been working on this. So we've been trying to build that bridge between governments and citizens for over 5 years now. And these are some of the things that we've learned along the way. We can break down the process of participation, very simply put, into 4 steps. Now, I'd like to take you through those steps one by one. The first one being, how do we find out that a regulation, a law, a policy, a draft amendment has been put out and is seeking feedback, or a particular body is seeking feedback, right? It is a little bit scattered. It is a little bit all over the place, but we found some key helpful tips and some little tricks that help us keep abreast of all of the wonderful developments in the consultation space. Now, very simply put, one of the easiest ways is to ensure that you regularly visit the ministry's websites, the regulator's website, or the department's websites that in domains that you are particularly interested in. The second way is to make sure that you keep your eye out for national newspapers, and when it comes to states, also your state newspapers, your local newspapers, right? So again, one of the key mandates of the PLCP, as well as some of the practices that the regulators have put in place, is to ensure that the consultation notices actually reach the end stakeholders. So there is an effort being made. I think what we can do is supplement it by making sure that perhaps we set up global alerts for keywords like public comments, seeking feedback, consultation, along with, if you can, the domain that you're interested in. So for example, if you're interested in financial regulations, you can add keywords like SEBI and so on, or you can add environmental related domains and keywords, depending again, of course, on your subject of interest. There's also another way. You can look at legal aggregator websites. Now, websites like TeamLease RegTech actually put together all of the regulations as well as open policies and feedback. So they actually meticulously make sure that all of the regulators, whatever consultations are coming out, they put it up on their website. So that's another resource for you to follow. The other thing that we can do is look at the e-Gazette of India, as well as the state gazettes for draft laws that are coming up for notifications, along with amendments as well. The e-Gazette of India will give you a translation as well. So they'll be published in both Hindi and English. And the state gazettes will also have their own state languages as options. Lastly, another really easy way for all of us is to visit civis.vote. It is something that our team very lovingly puts together. By doing all of the above steps, I think we try and find all of the open consultations, make sure that they're summarized and available for you to respond to. So that's step one, which is who is even seeking our feedback? Where can we go and contribute, right? That's identify. Moving on to, all right, now I figured out the consultation. There exists a paper, there is a ministry, there is a body that is seeking my feedback. How do I proceed in responding to this? Now, prior to working at Civis, I've known about the organization, about the process of consultations, and I have been very passionate. However, there was always a barrier to entry for me personally, and I'm sharing a little anecdote on whether am I well-rounded enough, am I articulate enough, is my perspective enough, is the government really interested in hearing what I have to say? And so what we've done is we put some of these steps together for you to try and reduce that barrier of entry and to actually engage in that dialogue. One thing to remember is that absolutely, yes, there are lovely champions of the system, like our speakers today, and like so many others, who are very keen in hearing your feedback from your experiences, from your understanding and expertise. So some things that help build that well-rounded feedback, and something that we've also put together from experiences from policymakers, things that we've heard from them. One thing that they're really stress on is that they want specific and relevant feedback. So like Dr. Sahoo was mentioning, IBBI has, using technology, made a provision where you can respond to each clause of the circular. So that's, and also SEBI also puts together formats where they request clause by clause feedback. There's a reason for that, because it helps the regulators in actually understanding where the problem lies or where the concerns of the citizens are coming from. So as specific, as relevant, and as deep as you can into the feedback that you can go is better for the policymakers. Secondly, they are requesting your lived experiences, your expertise, your perspectives, and your context. So the idea really is to provide anecdotes, to provide data, to provide, if you can, wherever you can, through research or through data points that you may already be aware of, share those, share resources, share secondary information, but also make sure that you share your primary first-hand experiences. That's what makes the feedback unique. That's what the government does not have access to. That's what regulators are looking for. And that's what will really add value. Apart from that, while it's interesting and important to provide our perspective, we must also look at it from a collective um, perspective, because we aren't making policies in silos. We aren't making policies for 1 or 200 people even. We're making them for a 1.3 billion population. So prioritizing collective good, being practical about the kind of inputs that you're seeking, being practical about the requests that you're putting forth to the regulators and policymakers, I think, and prioritizing that collective welfare would be another thing to keep in mind. Solution-oriented feedback is also well respected and welcome always. I think new ideas is how we can really add substance to the work of governance that is happening across, and that's something that's also important. Lastly, I think bringing empathy to the entire process and to the subject at hand, whether it's finance, environment, urban development, rural health, whatever be the subject at hand, I think it's important that you bring empathy while you're crafting that response. I'll pause here and I'll let Antara take us through the last 2 steps.
Thank you, Shachi, and thank you also to our very engaged audience members who are asking questions. I want to assure you that we have them all written down in sequence and we'll address them in the Q&A as well. Shachi has emphasized, and I will take this opportunity to re-emphasize the importance of your feedback in the process. This entire process does not work without active participation from each and every one of us, and no input is too big or too small. So now you've drafted your feedback, you've thought about collective good, you've taken into perspective a lot of your lived experiences, you've put down your response, it's exactly in the format that the regulator or legislator is asking for, and you're ready to submit. I will now talk about what this process of submission looks like, and it might be slightly odd to some of us, especially those of us who will remember our academic days when we would work on the process of writing the draft or our project, but the submission would just happen at the last minute in a hurry and very quickly. So none of us really thought about submission as its own step. There's a reason why we've put it down and why Shachi's actually articulated it as its own step. Because oftentimes a lot slips between the cup and the lip in the process of actually submitting feedback. To ensure that the feedback reaches the right person at the right time, there are a few guidelines that we must keep in mind. One is an adherence to deadline. We have noticed, and it's only understandable, that any regulator, government body which is dealing with a large volume of feedback needs to ensure that it all comes in by the deadline so that they can actually process it internally. Another quick tip here is that oftentimes if you are looking to see if a particular regulator has extended the deadline, frequently we see that it comes through at about 4 p.m. The day prior to the deadline expiring. So that's a good point to know. If you've reached 4 p.m., there's been no extension, chances are you may not get one. So better cobble together the feedback and share it through. There is also submission through specified channels which takes place, and we do have a question about this as well. So there may be certain channels or certain portals which the ministry or department is advocating for you to submit your feedback. It's always good to be aware if that is the only mode or if there are multiple modes that are being requested. Using aggregators like Civis is another option where you can actually come in and through the aggregator share your feedback, which will then again make its way to the government department, and that way it becomes the aggregators the responsibility to make sure that the deadline is met, that your representation is made in full, and that your voice is heard. Another very, very crucial and important way of engaging with this process, and this also goes back to Shachi's own anecdote that she shared of being intimidated as well about how much of your own feedback is relevant, is to collectivize submissions and to actually work with organizations like CUTS to make joint representations on particular policy decisions. That has many benefits, and we'll have some time for the CUTS team to take us through some of their examples as well. But one of the outlying benefits that I want to share is the fact that collective submissions highlight the importance of a particular cause. They also give a lot of legitimacy because you're going through an organized representation. And it allows you to share your lived experiences with experts in the domain like CUTS, and for them to make a representation on your behalf. So I'd like to re-emphasize that this is another very important way of actually engaging in the public consultation process. And those of us who have in the past submitted feedback through CUTS will know how effective this can be as well. The last step, and also a very equally important step, is attending meetings and making your points through various channels. Mr. Rao mentioned how news reports are a good source of information to understand the broader sentiment. It is equally important, if you have the time, and I know that time is our most precious commodity, to actually attend some of these consultation meetings, to go in person and make your representations in a manner that is required. Lastly, what do you do once you've made your submission? Collective action, like we've said, is very key to bringing change. And unfortunately or fortunately, I feel like it is also our responsibility to share this opportunity further. Sharing the consultation through social media platforms with relevant information, or circulating this information on our family WhatsApp groups, or on any of our college alumni WhatsApp groups where everybody is debating the pros and cons of certain policy. I often think about this process as actually converting all of the charcha that happens in our various personal spaces into constructive dialogue that can be shared with the government. And each one of us plays an important role in making sure that conversion from charcha to conversation actually happens effectively. And your role in this process is very simply to share the information about these consultations, to help others overcome any barriers to participating in the process. Each one of us becomes, as we start to engage with this process, an individual change maker. And by extending your sort of circle of change, you are bringing more people into the fold. So I would like to encourage everybody to think about how do you share and how do you ensure that more representations get made to these policies as well. Moving forward, I think Shachi and I would like to invite Arima from the CUTS team to perhaps take us through some of the examples that they have had of engagement consultations. Do continue to share your questions in the chat. We do have time for the Q&A as well, so we will address those queries.
Thank you, Antara. So good afternoon, everyone. I welcome you all to the online workshop on empowering consumer voices, navigating public consultation for effective policies. But before we begin with a case study, I would like to tell you a little bit about our organization. So CUTS International began its journey in 1983, and it has its headquarters in Jaipur. It has its centers all across India as well as abroad. So the aim of CUTS is mainly to achieve consumer sovereignty in the framework of social justice and equality. So basically, coming to the case study that is on consultation paper on OTT services. So basically, what are OTT services? These OTT services basically refer to applications where providers deliver audio, video, and other media over an IP network, such as the internet. So what can be the example of such OTT services? Like, for example, we have WhatsApp, Google Meet, Zoom, Instagram, Facebook. So these all are covered under OTT services. Apart from this, we also have telecom service providers. These examples can be Reliance Jio, Vodafone Limited, Bharti Airtel, etc. So basically now the revenue generation has shifted from traditional SMS and voice services to data usage. So here the question comes that why do we require regulation of these OTT communication services? So because as I told that there has to be a fair competition between OTT platforms and the telecom service providers. So right now the telecom service providers in India, they are governed under several laws. For example, there is Indian Telegraph Act of 1885. Then there is Wireless Telegraph Act of 1933, and then there is Telecom Regulatory Authority Act of 1997. So the telecom service providers, they have to abide by the rules and regulations, and they have to provide a fee to the government for providing their services, and they have to also have to make sure that the consumer safety is also ensured. On the other hand, the OTT platforms, they provide the same services, but they are not, they don't have to face any such requirements. So this leads to unfair competition, as well as it impacts government's revenue from the telecom sector. So if we basically have a legal interception of these OTT platforms, then it will ensure that there is a safe online environment where all the illegal activities, as well as there is the spread of misinformation, does not take place. So what I'm trying to say is that in the consultation paper that we had, so this was the gist about the paper. And apart from this, we also had a draft telecommunication bill in the year 2022, which aims to replace all the 3 acts that I mentioned. And it also provides that the OTT communication services should acquire a license, and it should comply with the same set of rules governing telecom players. So this was regarding the consultation paper of TRI. So when CUTS had to provide comments and suggestions for this consultation paper, so basically it was analyzed from the point of from the consumer's point of view, that how it will impact the end consumer. So it was analyzed that the proposed regulation, it will lead to increased cost to the end consumer, as well as there was a significant risk of deterioration in the quality of services that are provided by the OTT platforms. Also, there was one analysis that the OTT platforms are already currently governed under the IT Act as well as the Digital India Act. So if we have over-regulation, then it will have unintended consequences. Similarly, there was a significant risk of increased network usage fee. So this point was also highlighted by CUTS. So how did we come to this conclusion, or how did we analyze all these things? So I would request Sachi to, yes. So as you can know, yes. Thank you so much. So how did we come to this conclusion and analysis? So as you can see in the slides, that we engaged in extensive research. So we had one-on-one interaction with almost more than 100 consumer groups. We conducted surveys, and we had literature reviews. So all the literature that is already available, we compared it with the other jurisdictions, that like what is happening in other countries and other sectors. So this is how we go about engaging in the regulation making process and being a part of the collective consumer representation. So can you please move on to the next slide? Yeah, so these are the submissions that we had on this TRI consultation paper. So we had provided our comments as well as counter comments. And these you can access these on our websites of CUTS CCIER website. So this was regarding the consultation paper on OTT services. So finally, I will like to end by informing you all about how you all can engage with CUTS International. So I have provided the email ID, the website, as well as all the social media handles that you can. That's how you can contact us for any such thing. So basically, this case study we included in this session was to make to share our experience with you all regarding the consultation process, as well as what lessons we learned from it. So that is all from my side. Thank you. Thank you.
Thank you so much, Arima. I think we all benefited from that. Really appreciate you going into the details of the case study, and especially the way that CUTS collates that extensive feedback and puts it together. I'm sure we're all inspired to sort of come in and take action as well. At this point, what we'd like to do, we have about a little less than 40 minutes remaining together. And I know that we have had a lot of questions coming up in the chat. So what we'd like to do now is address them one by one. So also, apart from addressing the questions, I would love to invite all of the members of the audience, in case they'd like to come in and share their experiences previously, good, bad, confusing, however they've been so far in engaging with the public consultation process in whatever capacity that you may have. So this is a little time that we have for the next 10 to 15 minutes. What we'd like to do is try and engage with some of these questions, open that dialogue, have that conversation that we're so keen to have. Antara, do you have the question?
Thank you, Shachi. Yes, we do have a number of questions that have come in. we'll just, I know that we have a few members of the audience who are also keen to share their experiences. However, I'd just like to start with a few of the questions that have come in slightly earlier in the conversation. And invite also Dr. Sahoo, if you'd like to come in and share your perspective on some of the questions that have been raised. We have two questions, one from Mr. Rajesh Gajra as well as from another participant. Rajesh Gajra says, is the time period for consultation given for consultation between 0 to 30 days, is that adequate for the consultative process? And we'd love to hear your thoughts on it as well, Dr. Sahoo. The second question that has come in a similar vein when it comes to procedurally how the consultation process is taken forward is that currently, increasingly, the government seems to be keen on routing most consultations through the MyGov website. While having a consolidated source might be useful, it's very difficult to navigate that website, like making an account, etc. And any tips in that regard? So, Dr. Sahoo, if you'd like to come in on either of or both of these questions, and then we can move ahead.
The regulations sometimes made in an urgency. Sometimes it's a more of improvements in the systems and practices. So where it is something to be done urgently, there is a problem and it has to be addressed overnight. For that, law typically allows, in fact, all the public consultation we talk about, some people, some regulators like IBBI, IFSCA, they have formalized the process of making regulations. And there they say, and in fact, the new Competition Amendment Act also says that in case of urgencies, you need not consult the public, you go ahead and have the regulations, but the life of such regulation is 6 months. So you get a breathing time of 6 months to consult and do the complete process. So therefore, there is no reason that the regulator should give a short window of 7 days, 10 days, or even 3 weeks. It's possible to give a longer time. If there is urgency, do it by any means, but no need to hurry up, because this consultation is not just a formality. You are actually allotting the market people to get ready with the new regulations. In our context, particularly when quite often we bring in regulations with immediate effect, in contrast to, say, in the European Union and America, if they have to bring a major regulation, they will give 2 years notice. We make a regulation today in 23, it will come into effect from 1st January 2025. So when we do not give such time limits, we need to give reasonable time for people to prepare. In fact, not only the people should comment, the regulators should go around and talk to the people. And for that, regulator also needs time. So I think they have to be given decent time, and typically they should get time in 2 rounds. One is making the submissions on a discussion paper, one is on draft regulations. So if they get 2 rounds with 3 weeks of each, I think that is good enough. But I also brought to your notice one practice which IBBI does from its very first year, that you get 9 months in every year to suggest what change you want. So if every regulator gets 9 months every year to do that, he will not feel bad if he gets 3 weeks on a discussion paper and 3 weeks on a draft regulations. So this is my submission about the timeline. Yes, there can be a central website, but this is not something that if you do at central website, you will not do at a nuclear website. You can do in many forums like working group, advisory group, round tables. All routes should be open. So just because you go to a central website does not mean that IBBI will not use its own website. So do all possible means to reach out to people, and that too when this technology-based consultation does not cost you. But over and above this technology-based, the central website, all those things, unless you talk to people in person, even after having the advisory committee, working groups, some committees, you need to talk to people. And if you do not talk to people, you still do not get the essence. And at least I can tell that IBBI in its initial year, in every year, it used to have 200 roundtables. So that was the kind of engagement which makes the regulations so robust. So actually you have to be in touch. You have to find out where, how to intensely get engaged. Technology or one's website, it does not matter actually. Let those things happen as a matter of formality, but do it more seriously. Thank you.
Thank you, Dr. Sahoo. I think if I may just add one more point to what you mentioned, there are indeed legislations, like for example, the digital DPDP and other recent data privacy and protection laws that have come out on MyGov as the primary mode of consultation. But as Dr. Sahoo mentioned, I feel like there is a lot to be said for advocating for different methods of actually sharing feedback. And also working towards at least sending in postal responses or other forms of responses to the concerned ministry at the time when the consultation window has been opened. With that, I think there are a lot of different questions that are coming in. We have one more question for Dr. Sahoo from Navneet Sharma, which I'd just like to relay. Dr. Sahoo, Mr. Sharma says that you have been at SEBI, CCI, IBBI, and have observed different regulators as well in your many roles. Could you give us a quick academic evaluation of the consultation process design of the Indian regulations, Indian regulators as a whole?
No, I didn't get the question. What is the import of academic evaluation? I didn't understand the question actually.
Right. So I believe it's that you have seen many regulators from a 15,000-foot view. If you could perhaps outline some of the best practices that you have seen from different regulators, I believe that is the intent of the question.
No, best practices, in fact, I spoke in my talk, and in fact, and I also stated that SEBI is the pioneered the consultation process in the sense we mean today. Though it existed, I mentioned earlier also that say Chartered Accountant Institute, if they have to make some regulation, that goes through a prior consultation, prior publication in the Gazette. Securities Contracts Regulation Act requires a prior publication, and then there's a final publication. This was happening in the 60s and 70s, but in the current format what we talk about, it began with the SEBI in 2002. And the way we did then in 2002 and the way we did today are quite different actually. SEBI has evolved, everybody else has evolved. And the process of making the regulations, and particularly, as I just mentioned, the Competition Amendment Act says that how to make public consultation. And that gives very in a skeleton way. But IBBI's regulation gives in a more detailed way how public consultations are to be made. So public consultation, as I earlier mentioned, that the best practice is that have consultation on regulations, legislations, subsidiary directions, one. Second, have consultations for both reviewing as well as making the regulations. Three, while making the regulations, please help the regulated with an regulatory impact assessment. Fourth, while making a review of regulations, please tell that how the existing regulation has worked and what was its original objective. Enable the people to appreciate that. Then also use the technology. Use, most important, as I just mentioned in the last question, talk to people in person in smaller groups of 20, 30, 40 people, much more intense way. And over and above this, please make the regulated in the shoes of the regulator. Let them tell this is the regulation we want, and let regulator give a comment on that. Just the opposite of the regulator commenting on regulated suggestion. So let now the suggestion be given by the regulated and let the regulator comment on that. I would say these are the of all these other standard things like that, transparency is required. You get comments, give comments on comments, and those are available in public domain. Those practices are there, including the board should see the entire suggestions that have come. In fact, half of the board should have been engaged, half, it is more than half. The whole-time members and the chairperson, they are relatively number-wise much bigger than the part-time members. And all these whole-time members, they have engaged with the regulated or public. So they have already have a feel of the things. Only the part-time members have to be told what went in the consultation. So these are, I think, would be the practices I would suggest. And in fact, all this in the regulatory practices in the regulatory area, there have been from time to time different committees which try to look at what more or what better can be done. And somebody mentioned earlier about the financial sector legislative reforms commission, which was taken up by FSDC, that 2013 resolution, I think Mr. Kadra referred to. And there have been several, Mr. Damodaran committee, several committees, including the Administrative Reforms Commission. So the best practices I always would try to capture. One of the latest one I would say is that the expert committee on the valuation profession, which was a committee of a Ministry of Corporate Affairs, and that gives the best regulatory practices in every area. And I would say that that is the state of the art thinking today. And though that report is a 2020 report, but that is the state of the art thinking. Thank you.
Thank you so much, Dr. Sahoo. And I think that re-emphasis has really reiterated the best parts of the process for all of us. I know that Mr. Gopal, who has joined us as an audience member today, is keen to share his experience of participating in a consultation process. Mr. Gopal, I think I'd like to call upon you to share your feedback in perhaps a minute or two, because I'm sure your input will also give rise to many questions for our audience members to tackle. So if you'd like to unmute yourself and share your feedback on having participated in this process. I'm sorry, but I'm unable to hear you. I can see that you have unmuted, but I don't think we're able to catch your audio yet. We'll just wait to iron out this this glitch in terms of audio and video, that we're not being able to actually hear or see Mr. Gopal. But in the interim, I would just want to check with Amol, if you would like to come in and share perhaps some of your experiences of having engaged, or perhaps some of the stories of the consumers who have engaged with cuts and how that has impacted the process.
So thanks, Antara, and it's a pleasure. But before that, I think I would just, on behalf of CUTS, also like to thank Dr. Sahoo for sharing his perspective, particularly the innovations that he has been able to put together in different forms, and his idea of shifting the roles of regulated and the regulator, and why should not the regulated take the driving seat. But I would like to, with due regard, sir, make the submission that at times we have also seen that there are different types of regulated entities, and there is that fear of regulatory capture. So how do we balance that? We have appropriately taken into account all the feedback on a particular issue, and not just from one type of regulated entities. And also consumers and citizens are not necessarily falling within the definition of regulated entities, but they must also be allowed to initiate this process of regulation making and make suggestions for issues which need to be regulated or deregulated. And I think there have been some expert committees in the past which have talked about giving this right to public to highlight issues which would require a regulation or which would require revisiting the existing regulation. And that is something which we should definitely maybe think about.
Okay, so about the consultation is not limited to regulated. That's why we call it public consultation. But we expect that relatively more intensive engagement will happen with the regulated, because common people do not understand, do not have interest. But yet, like we talk, I think again, this regulatory practices, the best regulatory practices, one that valuation committee report I refer to, or if you look at the competition law review committee report, they are saying that engage with the advisory committee, all those things, but have some eminent citizens who are no way related to the subject on the governing board of the regulator, and number of such members should be more than the number of whole-time members. Something akin to independent director number exceeding the dependent directors. So then you have a representation of the society. The whole objective is you want to bridge, you want to improve the democratic legitimacy, and you have to do on many fronts. So one is that get eminent citizens. Supposing we are talking about securities market, we want a person who does not understand securities market, but who understands country, society, culture. We want a person like that who is able to see the intersection of the securities market with the rest of the society. So therefore, first check is actually bring the public view through this part. And thereafter, your engagement should be also, as you engage with the regulated, but you engage with the others also. So you have the roundtables, personal discussions, all those things. Ensure that your composition of working groups or the advisory committee that has also public views. So some way you have to involve public. It's not that it has to be only regulated. Of course, regulated has a bigger stake because their interests are immediately affected, and probably they are taking the cost and benefits. So definitely they have a right that they should have, but not that others are ignored. About the regulatory capture, there are again so many ways. One is this way, just discuss that if you have the eminent citizens on the regulatory board, if you have the best and the antidote for the regulatory capture is the professional capability of a chairperson and the members of the regulatory board who cannot be befooled. Regulatory capture happens when actually these people are befooled. So you have that system. Look at the basics, the corporate, the governance. Have a system that who put the people in charge, who understand and who cannot be befooled. And again, also they must be able to understand who is generating public comments. Somebody is generating lakhs of mails just to push one view. They should be able to see that. And there will always be, it's not majoritarian at this stage actually. They should be able to see, okay, one lobby is trying to capture, but there are some senior voices, there are some public voices, which regulators should be able to hear. And that requires a regulatory capacity actually. So, and again, there are many ways to avoid regulatory capture, but the route is, for everything, route is a governing board. The board must understand, board must have public people, board must consult the people, board must approve the draft regulation. Everything begins and ends with the governance of that regulated body. Ensure that the rest will fall in place.
Absolutely, sir. I think putting responsibility and accountability to the board is the best way forward. Absolutely. I think Mr. Gopal is back with his audio and video. Mr. Gopal, can you unmute yourself and share your experience?
Yeah, I hope you can hear me now.
Yes, sir. If you could introduce yourself and also talk about
Yeah,
your
sure.
experience.
Yeah, good afternoon. First, let me thank Civics and CUTS for giving me this platform to voice my views on this. I am the Secretary of Consumer Care Society, which is an organization based in Bangalore. We have been in this field for the last 30 years. And we have been interacting with CUTS and with many regulators, both at the center and the state level. Okay, so that's a basic background. We are a membership-based organization. We are about 300 members ourselves. Okay, so that's the background. Having said this, first let me thank Dr. Sahoo and Mr. Pramod Rao for a very interesting and informative presentation. I have a couple of observations, and of course, one I think which Amol had already covered, which is on regulatory capture. Now, the issue is, of course, the governing board. I have a follow-up question, and my observation on this is that people who are regularly interacting with all this consultation paper also have to be given a little feedback on how their views have been, or suggestions or comments have been accepted. Okay, because normally what we find is one of the things is that you spend a lot of time and effort in putting up the feedback on all these consultation papers, and many a times you do not get any feedback on how this has been received. And then finally the policy has been made, you really do not know how the inputs have been aggregated. Now, I know this is a very difficult issue because there are so many inputs that come from different stakeholders, and obviously it is a humongous task. But I think it is very necessary to because then only the transparency is there, and obviously the involvement of all the stakeholders is possible. Otherwise, there will be a dropout at many stages, because basically people will feel that the consultation is merely an eyewash, or at the most just a process to keep things in place. So this is my one major view. The second thing which I think Dr. Sahoo mentioned, and that is very, very important, because what we find is most of these consultation papers are floated by the regulators basically on their own initiative. And many suggestions which we have given to different regulators, I do not want to name the regulators here, have not been accepted as far as a consultation paper. Obviously, maybe the regulators don't feel these topics are very big enough for a regulation paper to be floated, but it is very important because it is from the regulated point of view that we are voicing this opinion. Okay, the regulated feel that these areas needs to be addressed by the regulator, but unfortunately that never seems to be happening. Okay, so we find that the points on where the issues are taken, it can be in financial sector, it can be in the stock market. We find this is across all regulators. So, okay, where the issues which concern the regulator are very rarely taken up. Okay, so that is one. Of course, the other point which somebody already raised is the time process. And we find many a times that the time given is pretty short, especially when none of it is an emergency basis. And obviously, I think there are other issues maybe that are involved here. Maybe the pressure is from somewhere else. Okay, so these are some of the topics that we found our own view. And of course, here I think that there is another need for us to also look at it. We should have a sunset clause on many of these regulations. Okay, some of these regulations are not touched upon till a long period of time, and because today we are in a dynamic situation, we keep mentioning it, it become almost a cliche. But then the point is regulations are kept in place for a very long period even today. So I think we need a sunset clause on this. And the last point is maybe my personal opinion, but many a times I think there's a top-down approach in many of this policy making and consultative process. Okay, and obviously the regulatory capture is there, and obviously you find that even in the consultation process, it's not a pure consultation process. It is more a feedback process. It's more a comment and suggestion. Where is a consultation? You don't voice, and if you voice, there is no reaction from the regulators and other stakeholders. Everybody voices their opinion, and many a times, there is no actual discussion and consultation. I know there is paucity of time, that is there, but then unfortunately, if that is the reason given, then there can be no consultation at all possible. Then we should restrict the consultation to very selected few. But the whole idea of this consultation process is we need a broad variety of people, like I think Dr. Sahoo mentioned. We don't even need people who are experts in a particular field. We want cross expertise from different fields. Okay, because today the impact doesn't happen only in one field, it happens across fields. So we need people from other fields also to participate. So if that is the case, then I think this consultation process will be a little long drawn, but the regulator should be willing to go through that process. Thank you.
Thank you, Mr. Ratnam. I think that was a very interesting point and point well made on your part. Excellent to learn about the work that you have been doing in this domain as well. Dr. Sahoo, would you like to take the opportunity to respond to any of the points that Mr. Ratnam has brought?
Well, one response, if one takes an opposite view or a different view. I do not have any different view, and all that he told, at least at IBBI, I have practiced everything.
Right.
So this consultation process I told you, I myself participated in 200 consultations, roundtables individually, and others also participated. And shortage of time, IBBI was set up on 1st October with a mandate to operationalize everything by 1st December, flat 60 days time. Within that time, ecosystem has to prepare, investor, insolvency professionals, professional agencies, so many things to made, regulations to be written, but that didn't come on the way of consultation with stakeholders. I don't think regulators, government, anyone is short of time. And as I told you, if you are short of time, you have an emergency way. Go ahead with the emergency way. There's absolutely no shortage of time. Consultation through technology, all those things are good. Those are to increase the reach, but you need consultation, individual, personal consultation, not individual, personal consultation in groups of 20, 30 people where you are able to hear 3 different opposite voices. So A says something, B says that's not correct. Then only actually you understand, but not that they have given the written submissions. So engagement has to be really intensive, really personal. And that's why I told that it's not only chairperson, the full-time members should go out, executive director should go out. They should talk. That was one. Top-down, as I told, yes, top-down approach is there, but IBBI has created a bottom-up approach also. You get 9 months to keep on suggesting. So there is, and every regulator, I would say every regulator, government, everywhere, there should be top-down approach, there should be bottom-up approach, because ideas can come from at either place. So there is no, they are not substitutes. When from top people feel something good is there, let them consult others and do it. And when people at the bottom feel, let them give the idea and let those be deliberated. So it is, these are not substitutes. In making law, both things should continue to exist. Inputs will come in public consultation. You get different inputs from different people. Again, look at the IBBI regulation, look at the Competition Act. Now they are saying that you have to put out all public comments you have received, but you need not comment on each comment you have received, each suggestion you have received, because many suggestions are repetitive. So you can say that I have received suggestion A from 120 people, and I am rejecting this 120 because of this. So that is acceptable, and that is the practice IBBI does, ERA does, TRI does, and maybe few others are also doing. So it's not possible that you write down same thing everywhere, and actually if you do that, people will not get real meaning. Supposing if you list out 1500 comments and there's repetitive answers, people will not really understand. But if you summarize it, if you say that this kind of comment I have got from 150 people, and I reject this for the following reasons, and that rejection should come from the board, not the officer of the organization does. So I can't disagree with Mr. Gopal Ratnam. So broadly, I'm fine with all those suggestions.
Thank you, Dr. Sahoo. Thank you for your perspective, I would say, rather than response. I'll just request Shachi to perhaps take us through some of the action points on the pre-legislative consultation policy and the way forward. Before we kind of move into some of the examples of how citizens can engage in this process, and we have no workshop ends without homework. So Shachi will of course take you through some of the homework that we have for all of our participants. I would just want to re-emphasize some of the conversation and perhaps bring together some of the key points from the last almost hour and a half that we've spent together. I think Dr. Sahoo has made a very important point that the policy process empowers citizens, but also gives the responsibility to participate in the lawmaking process continually, not just as a one-off or a one-step. What you can do as a citizen is respond to consultations whenever they are put out by the ministry, state, or regulatory bodies. You can ask questions to the relevant parliamentarians, the administration, and you can also file RTIs. Another very important tool that we have seen actually helps enable us to understand how the feedback has been processed over time. You will be surprised by the thoroughness in which at which the ministries and departments are actually looking for your feedback. The responses that they have, right by every response that has come in. However, due to certain capacity constraints, they may not be able to publish it. But if you ask through an RTI, you will get all of that feedback in response as well. Another very important facet of conversation which has come up today is the bottom-up approach. So that is, we again emphasize the need to demand for consultations on laws which have not undergone the process, or the need to make certain concerns known to regulators and use those windows like the 9-month window at IBBI to ensure that regulations go through frequent revisions and more conversation. Lastly, to advocate amongst fellow citizens and spread awareness on the consultation process, as well as the ways to participate in this process. I think this is an incredibly important way to go ahead, because like our eminent speakers have highlighted, all of this is a process of evolution, and we are part of that evolution in every step that we take of active participation. Before I again hand it over to Shachi, just want to quickly thank members of our team as well. Shachi, who has led this entire effort and actually put together the slides for today, as well as my colleague Shinotra, who has been working tirelessly behind the scenes to make sure that this webinar has been circulated more widely. So with that, Shachi, do assign us our homework, and I'd request you to thank our partners at CUTS and close out the session as well.
Thank you, Antara. She's already given you the spoiler, and the homework, very simply put, is to put all of the wisdom that we have received from all of our speakers today and to put that into practice. Now, there is an open opportunity. One of the many consultations that are currently open for feedback, and you can find all of them, including this one, on the Civis platform and on all of the other channels that we have previously mentioned. One of them, and we believe that I think all of us do tend to have an opinion about some subjects when they come up. One of them being, how do you make digital inclusion a reality, right? So the Telecom Regulatory Authority of India, TRAI, has put out a consultation paper seeking feedback on the different ways that digital inclusion can become a reality. Now, we all understand, and this is in the era of emerging technologies, in the era where 4G replaces 5G, replaces 6G, and you know, we don't even know when we'll end up with the next set of new revelations from the tech sector that will really change our lives. When the revolution is moving that fast, how do you ensure that all of your population is keeping up, right? And what this paper, interestingly, is an exploration of this concept itself. What digital inclusion even means? How can you define it? At what point can you say Digital India has become a reality? What percentage of population needs to have access for that to have become a reality? What populations or what sections of the population are currently the ones that are lacking access, that are falling behind? And how can the focus, and of course there are already programs, perhaps the National Broadband Mission, as well as the BharatNet programs that the government have developed to try and bring the digital inclusion and make it a reality. But try seeking your feedback on how that process can be speeded up and be expanded to include every last citizen of India. The entire consultation paper is available in 2 places, of course. The TRAI's website itself, and the paper is self-explanatory. It is given in quite a lot of detail. They've defined very basic terms. They're trying to ask for a more detailed approach or a more theoretical academic perspective as well, should you wish to provide that. The other place that you can find this consultation is, of course, our platform, civis.vote. You will find a short summary of the entire consultation paper there as well. You'll also find a translation for that short summary in Hindi. We've also put together some key questions as identified by what TRI is trying to seek feedback on. So you can go ahead and respond directly to TRI or through the Civis platform. And I hope all of us do indulge and do engage in a lot more consultations going forward. Antra has already done a quick vote of thanks. I'd like to extend that further to everybody at CUTS. Dr. Sahoo, it's been an absolute pleasure to hear from you. Mr. Pramod, who's not with us on the call anymore, but thank you so much for your inputs, and we're just really, really grateful for this lovely session. If there are any upcoming questions, if there are any other conversations that we've perhaps not been able to pick up, please feel free to write to either of our organizations on our platforms, and we'll be happy to get back to you. Thank you so much for joining us. Have a lovely evening.
Thank you, Shachi and Civis team. And on behalf of CUTS also, I would like to thank everybody, particularly Dr. Sahoo and the people who have opportunity to ask questions, and Mr. Ratnam. On the TRI consultation, we are also putting together our comments, and feel free to write to us. We'll be happy to engage with different groups to submit a collective representation. And let's keep this a practice and put our forces together, as Dr. Sahoo has also mentioned, to be in the seat of regulators from the making that transition from being a regulated entity. So thank you very much. Thank you, Dr. Sahoo.